And Roisin is an assistant professor at the School of Law and Government in DCU, and she holds a PhD from Trinity College just down the road, but also has other degrees, including a master's in international affairs from the Institut d'études politique de Paris. So I'll hand you over to Roisin.
Thanks so much, Edgar. So I suppose I'm going to start off providing maybe, as I'd already said, kind of a broad context for some of the constitutional issues that kind of underlie debates about adequacy and the adoption or the movement towards an adoption of a UK-specific privacy law following Brexit. So I'm just going to share my screen so you can see my slides. And hopefully everybody can see that. Yeah, okay, great. So I suppose my my interest really in this is motivated by, I suppose, a general interest in the way in which the UK treats privacy differently and maybe uniquely in terms of member state treatment within the European Union. That's been accommodated at times somewhat uncomfortably within the schema of EU privacy law while the UK was a member, but it's going to be increasingly, I suppose, difficult to accommodate without probably fairly significant rethinking of how it will operate on a day-to-day basis if the UK is looking for a kind of adequacy agreement, and certainly when we look at the way the Charter has come to influence the way the GDPR is read, which I'll speak about in a moment. So I suppose my concern it was with that. I suppose the concern specifically arises in the context of Brexit when you look at the kind of intersection of influences around, or the tension maybe that is situated at the confluence of the EU's export power in terms of exporting regulatory standards and particularly data protection standards, and the UK's power to push back against that and assert a very common law view of what privacy is and specifically how it should be protected. So I suppose a sort of uncontroversial background that the EU has enjoyed a significant amount of international influence in terms of privacy protection, certainly if we're conceptualizing data protection as an aspect of privacy, which I think is a fairly acceptable way to begin by framing this. But the GDPR is probably the zenith of that kind of influence. If you look at Graham Greenleaf is always releasing his statistics, he's kind of running tally of how many jurisdictions have adopted laws which are indirectly or sometimes very directly influenced by the GDPR. And he kind of lists about 146 globally, 148, I beg your pardon, where there are data privacy laws, and some 140 of those displaying a very kind of dominant influence of the GDPR itself. And that's led kind of various people to conceptualize the EU as this kind of sovereign in respect of data privacy, as a market leader. That's all, I suppose, well and good in very kind of rhetorical terms. But I think our concern needs to be far more fundamentally, apart from labelling this as the Brussels effect or anything like that, which I'll come to in a moment, to look at what we're actually exporting when we export the GDPR, and whether that raises constitutional issues for the UK in a post-Brexit setting. So I suppose that's really the fundamental crux of what I want to ask with this paper. So the Brussels effect, I suppose, for a little bit of context, is kind of an update really of a pattern identified in the 1990s in respect of California's regulatory power to influence environmental standards and then somewhat later data privacy standards. I suppose the interesting thing, and the thing which is maybe fallen away when we talk about the Brussels effect as Bradford has identified it, is the common core that underlies California's export of those standards to other states within the US. So if we're talking about the California effect, it's all well and good to acknowledge a regulatory impact where standards flow out from California and other states tend to adopt them. But of course, all of that is happening on a regulatory landscape which shares a common constitutional core. There is, despite different state constitutions and different ways in which federal laws might be provided for in state contexts, a common understanding of constitutional principles and constitutional rights which underlies that kind of landscape. And I think one of the problems that we haven't really perhaps identified and addressed as fully as we need to when we're talking about the European Union's power to export data protection standards through the GDPR and to other kind of maybe softer mechanisms, is whether that common core is present. And when it isn't, when we're exporting these kind of standards beyond the borders of the Union and maybe beyond the borders of kind of maybe even EC or HR states, what kind of core of values is present? And is that compatible with the values that the GDPR incorporates and seeks to promulgate very fundamentally? And I suppose in that respect, it's, I suppose, very important to conceptualize the regulation as a constitutional mechanism, really, or a mechanism giving constitutional effect, or I think a very horizontal effect to constitutional values. So if we think about, obviously, Article 16 of the Treaty of the Functioning of the European Union and Article 8 of the Charter of Fundamental Rights, there's a very, I suppose, fundamental constitutional aspect to the fundamental right to data protection. And of course, the GDPR now, and especially, I suppose, as the Court of Justice emphasised in Schrems 2, has to be interpreted in light of the Charter. But a more fundamental principle of interpretation would say that given those constitutional values that underlie the European legal system, there was never any way it wasn't going to be subject to those kind of controlling or superior constitutional forces. And we see the GDPR acknowledging that to some extent. The recitals kind of make current reference to fundamental rights. And Article 1 of the regulation itself says the objection of the regulation is to protect the fundamental rights of natural persons. But I think what's really the most important thing to remember is whether we look at it as a very hierarchical Kelsen grunge norm of these are constitutional principles that flow from the most fundamental documents, like the treaties and the Charter, through to the text of these secondary laws, or whether we look at it like the CJEU does much more functionally as we need to interpret secondary laws in a way which corresponds and complements the meanings of the Charter. It is fundamentally, when we're talking about the regulation, a sort of quasi-constitutional document at the very height of its potential, and at maybe the minimum threshold of its potential, a document which has significant constitutional inflections. And so I think in that respect, we need to query what we're actually exporting when we export the regulation, when the Brussels effect takes hold in respect of data protection. It's very easy to export regulatory standards because policy launder them as you may, you can trace back the origins of the particular standards involved. They can be subject to the kind of impact assessments and risk mapping which you would apply in the jurisdiction where they were first adopted. But if we're talking about exporting normative standards, it's much more difficult to trace the source of the particular standard itself, and in particular the influences that caused it to take on a particular form. So if we look at privacy, for example, privacy in a European context, as it is included in the ECHR and is subsequently included in the Charter, and as it's conceptualised by the Court of Justice in its decisions, is a very, I suppose, historically, specifically contextualised right, and one which is a very specific social function. So it's contextualised very much as a kind of personality-based right, protecting, of course, the kind of very conservative idea of private property and the family's rights within that space, but also much broader ideas of dignity and personality development in social settings. And it includes not just that very conservative, restrictive aspect in terms of preventing the government from doing things, but as a result of its kind of social aspect, also a very significant positive element. In that respect, it's kind of unwieldy in some manner. Its margins are very difficult to define. It's incredibly expansive, but it is always socially situated by the courts in the ECHO in Luxembourg and Strasbourg when they're interpreting it in a very particular European context by reference to the Second World War setting of the rights documents involved. And I think by reference to some of the kind of social anxieties that underpin the way in which the right is conceptualized as a result of that historical origin. When we compare that with other jurisdictions, and in particular common law jurisdictions, of which the US is probably the most prominent example, the difficulty in defining the right and then exporting a normative value based on that right becomes particularly apparent. US conceptions and common law conceptions of privacy generally aren't necessarily as beholden to those kind of dignitarian or personality-based ideas, certainly not instinctively in the way European or civil law traditions are. And actually, that's one of the, I suppose, central problems with the kind of unadulterated common law approach to privacy, in particular as it's perhaps included in unwritten constitutions like that of the UK, that we're basing our idea of privacy in that context on a very, I suppose, traditional view of privacy as linked to property, as opposed to as linked to personality. So what we see in the UK, I suppose, is a gradual evolution of privacy rights from their kind of very common law constitutional standing, where there's this view there's no need for a standalone right, as Chief Justice Wolfe said, towards the kind of gradual accumulation of greater European law influences, mainly through the influence of Article 8 of the ECHR. But there continues to be a concern, I think, about what exactly privacy means in UK law, and whether the kind of tests that exist in that common law scheme, like the reasonable expectation of privacy, despite the fact that it has similar language to the language sometimes used by the CJU and ECHR, whether that actually provides a threshold which is not only in regulatory terms, but also in normative terms, equivalent to how Europeans understand the right to privacy. So I suppose what we're really talking about ultimately is looking at the constitutional origins and the constitutional rights, which are at the fundamental root of the Brussels effect. I think we need to interrogate quite significantly what precisely we're projecting those values onto. If we're exporting normative values from the European Union as one jurisdiction to another jurisdiction, to be very clear about what exactly that means, not only for us as the exporter, but also for the country that's importing them, in terms of its constitutional values and the way in which those are framed at a very abstract level, but also put into practice at a very practical one. So I'll leave it there, and I'll pass over to Eduardo, and happy to answer any questions as they arise. Thanks very much.
Okay, thank you very much. That's great timing. You almost made up, I think, a few minutes. Very interesting. There, as a chair, I have the sort of prerogative to say a few things, and I get my own point in before anyone else. And I guess we take the questions at the end after the discussion. But it does strike me that the concept of privacy is very different, even in the European context across different countries. If you compare Denmark with Germany, for example, they're neighbors, but completely different concepts. And if you ask for a tax, to see your neighbor's tax return in Germany, people think you're crazy. In Denmark, you can. You can actually go to the tax office and check it. So very different approaches. So that's kind of interesting also in the cultural background that relates to this.